Yes, ma'am.
Yes, Judge. This is ADA Sue Chan here, standing by, SAUCHAN.
Okay. Do we have Mr. Teasley?
He's right here on 4 South, the 4 South calendar.
Oh, there he is. Hey, Mr. Teasley.
Good morning.
How are you doing?
All right.
My name is Sean LaGrua, and I'm going to be handling your case this morning, all right?
Yes, ma'am.
As you probably understand at this point, the jail is not transporting folks to the courthouse. You have an absolute right to be here if you want to in the courtroom with me, but if you want to proceed without and go through Zoom here, we can do that. Are you okay with that?
Yes, Your Honor.
Have you had a chance to talk to, where's Miss Chant?
This is she. I think you're looking for Mr. Scheib, the defense attorney.
Oh, is Mr. Scheib's not on?
Okay, well, we'll go to position 11.
All right. Can we get, is Pamela Mitchell available?
She's coming, Judge. There she is.
All right, great. Good morning, Miss Mitchell.
Good morning.
All right, my name is Sean LaGrua, and I'm going to be the judge handling this calendar this morning. Because of the COVID situation, they are not transporting folks to the courthouse, but you have a right to be here if you want to be. We would just have to continue it. Are you okay going forward via the computer?
Mm-hmm. Yes.
Okay, and you're going to have to speak up nice and loud because with that mask, it's hard to hear sometimes, all right?
Oh, got your earring, caught your earring. Closer.
All right, the other thing that has to happen, and let me find the indictment. So usually you would be here to sign this indictment, right?
Yes, ma'am.
And the plea sheet.
Yes, ma'am.
Because we're doing this remotely, I need your permission to sign and initial on your behalf.
Yes, ma'am. Yes.
Judge,
Mr. Poole?
Judge, I apologize, but Ms. Mitchell is on the calendar for a bond hearing, or I asked that she be placed on for a bond hearing.
Okay.
So,
all right, we're here on a bond hearing then. Have you had an opportunity to speak with your attorney about this case, Ms. Mitchell?
Yes, ma'am.
All right, go ahead. Go ahead, Mr. Poole.
Judge, there was a bond hearing for Ms. Mitchell on April the 9th of this year. During that hearing, the judge heard argument and decided to change the bond. She had a $50,000 cash bond. The case was indicted. Some additional charges were added. And at the bond hearing of April the 9th, the judge changed the bond to $50,000 good bond or the sheriff's 10% program. The booking screen at the jail does not reflect the bond order of April the 9th. The booking screen at the jail, what it shows is for the charge of aggravated assault, there's a $40,000 cash bond. And for the charge of possession of a weapon during the commission of a felony, there's a $5,000 cash bond. And then it shows hit and run, which is $5,000 cash bond. I'm asking the court to consider two things. Number one, if there's an order or something that the court could do to instruct the jail to update their records to show that there are no longer cash bonds for Pamela Mitchell. The aggravated assault, the possession of a firearm by a convicted the possession of a firearm during the commission of a felony, the possession by a convicted felon, the charge of discharging a weapon, the total bond for those 4 charges for which she is indicted for is $50,000 good bond or sheriff's 10% program. But the jail records don't reflect that. I talked with the jail about this, and they brought up this unindicted hit and run charge. I understand that the state could re-indict and add the hit and run, but for some reason, they did not do a not present to the grand jury order. So, you know, even if the jail records are updated, that hit and run $5,000 cash bond will still be there. So my second request is I'm asking the court to set a bond for this hit and run. If the court's not inclined to set a signature bond for the unindicted charge of hit and run, which the state did not submit a not present to the grand jury order for, I'm asking the court for a $3,000 bond.
Who's the assistant district attorney on this?
Good morning, Judge. ADA Alice Holloway. I'm the ADA handling the case.
Can you tell me something about this case?
Yes, Judge. So the case started out as a hit and run. The defendant crashed into the victim's vehicle and then drove away without giving any information to the victim. And then the victim followed the defendant's car. And at some point, the defendant took out a handgun and shot at the victim. So it all started from a hit and run. So the state was not comfortable doing the NPGJ form on this on the hit and run charge. I would like to re-indict the case, but considering the state of grand jury right now, that's not available to me.
Well, is she willing to waive indictment and proceed on an accusation, Mr. Poole?
Yes, Judge, I was going to mention that. I've talked with her about that. She's called me several times. That's one of the things that we've talked about more than once. She is willing to waive having this case presented to the grand jury, since the hit and run is the only charge that would be added.
Is she on probation for possession of a firearm during commission of a crime?
Judge, she is on probation, but I don't know.
How did she get a bond with another possession of a firearm during commission of a crime?
Your Honor.
I could tell, what I know is when she came in at first appearance, she received a $50,000 cash bond.
Magistrate said it.
And then I filed the bond motion and asked for the cash bond to be changed. And it was changed to a $50,000 good bond or sheriff's 10% program.
Your Honor.
Ms. Holloway, what's your position? Hold on, probation. Let me just hear one thing from Ms. Holloway.
I guess I just want to object to what Mr. Poole is asking for, but I do think it's problematic the defendant received a bond in this case at all.
I do too.
I just
And
want
if we're
to.
back on a bond modification, there may be no bond until y'all work something out on the hit and run in the case. You don't get a bond when you are charged with possession of a firearm during commission of a crime when you're already on probation for the same crime. At least not in this division.
Excuse me, Judge LaGrua. I just looked through Odyssey at the first appearance order. This is Officer McGregory here.
Okay.
I looked at the bond order when she first came in October. Judge Frazier didn't give her a bond. She only had the one aggravated assault charge.
Well, I am not comfortable setting any further bond or moving on this. Y'all are going to have to go back to the judge it's assigned to for any modification, because if you want me to modify it today, it's becoming no bond. which I suspect you don't want me to do at this point. Mr. Poole?
Correct, Judge. Correct.
All right, I'll let you get back. Hopefully in the next few weeks, we're going to each have our own calendars, so you'll be able to talk to the judge. Now, the one thing I think you can do, Mr. Poole, is pull the order out of Odyssey and get a certified copy to the jail and meet with Ms. Holloway about getting that hit and run accused. So you've got it all together so you can go ahead and deal with it.
Judge, I heard what Your Honor said about the certified copy, but I believe the case manager has sent the order to the jail more than once.
Well, but there's an unindicted charge that she has no bond on, so she can't get out.
I understand that. I will reach out to the DA's office again. I heard what the court said, but I'm just responding. I've reached out to the DA's office about the hit and run, trying to get something done with that more than once, but I will reach out to them again. Thank you.
Miss, if you'll make sure you call Miss Holloway today, if y'all may not want to exchange numbers since we're streaming live, but if you will reach out to her, Miss Holloway, will you please get back to Mr. Poole today so y'all can get that moving?
Yes, Judge.
Perfect. All right. All right. Are we ready on Mr. Cooper? Mr.
Judge,
Miller on?
I am,
Judge,
Your
it
Honor.
appears that Mr. Sheeb has appeared now. So if Your Honor wanted, you could take up position 12.
We're going to go ahead with Mr. Cooper since he's available and Mr. Miller is ready to go.
Yes, Judge.
And then we'll come back to Mr. Schad. Good morning, Mr. Schad.
As I thought this was supposed to start at 9:30. I've been here in my office for a little while, but we're ready at your convenience. We're good.
You're fine. You're fine. Nobody's fussing. Are we ready, Mr. Miller, on Mr. Cooper?
We are, Your Honor.
Mr. Cooper, is this Mr. Cooper on 5 North?
Yes, ma'am.
Good morning, Mr. Cooper.
How you doing?
Good. How are you?
Fine.
All right. My name is Sean LaGrua, and I'm the judge on your case. We're here this morning. Have you talked to Mr. Miller about your case?
Yes, ma'am.
Okay. You understand that you have a right to be here in the courtroom if you choose to, but right now the jail is not transporting folks to the courthouse. So we can either do this via the computer and the Zoom program, or we can continue it for some later time when you can be here in the courtroom. What would you like to do?
I'd like to continue now.
Okay, so you're okay with not being in the courtroom?
Yes, ma'am.
All right, it looks like you have 3 cases on the calendar this morning. Is that right, or 4?
3.
Cases, Judge.
All right, you have 3 cases, and usually here in the courtroom, you would sign this indictment and a plea sheet, okay? That goes over all your rights. Do you understand that?
Yes, ma'am.
And has Mr. Miller gone over all that with you?
Yes, ma'am.
All right. Are you comfortable with me signing on your behalf as we go through this?
Yes, ma'am.
Mr. Miller, are you comfortable? And Mr. Whitenauer with me signing on y'all's behalf?
Yes, Your Honor.
No objection from the state.
All right. Go ahead, Mr. Whitenauer.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to be asking you some questions. Please respond out loud, yes or no, so that the court reporter can take down everything that we say. Agreed?
Yes.
All right, sir, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please lower your right hand. Please state and spell your true, correct, and full legal name.
All right. My name is Antonio Cooper, ANTONIOCOOPER.
All right. Sir, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No. We haven't. No.
All right. How old are you?
33.
And how far have you gone in school?
I completed 10th grade, but I have a GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged with the following offenses? An indictment 19 SC 170209, one count of aggravated battery, one count of aggravated assault. An indictment 19 SC 171211, possession of marijuana with intent to distribute, loitering, and possession of drug-related object. And a 19 SC 168252, possession of marijuana, fleeing or attempting to elude a police officer, and willful obstruction. Do you understand?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And sir, has your attorney reviewed with you what we refer to as a waiver of rights form?
Yes.
All right. And did you understand all those rights that he went over with, you?
Yes.
All right. And are you fine with the judge initialing that form on your behalf today?
Yes.
All right. And sir, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in these 3 indictments, including any potential defenses?
Yes.
Do you need more time to discuss the cases with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading in the indictment?
So waived.
And do you waive any and all defects in the indictments?
So waived for the purposes of this plea.
Thank you. And sir, has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes.
All right. With respect to indictment 19 SC 168252 on the possession of marijuana, that's a sentencing range of 1 to 20 years in confinement. On count 2, 12 months maximum in confinement, and count 3, 12 months maximum in confinement. With respect to indictment 19 SC 170209, with respect to counts 1 and 2, it's a sentencing range of 1 to 20 years in confinement. And finally, with respect to indictment 19 SC 171211, you were charged in that indictment on counts 5, 7, and 8. On count 5, possession of marijuana with intent to distribute, it's a sentencing range of 1 to 20 years of confinement. And on counts 7 and 8, those are misdemeanors, you face a maximum of 12 months in confinement. Do you understand?
Yes.
All right. And sir, do you understand that this is a non-negotiated or blind plea, and the state will be making a recommendation to the court?
Yes, sir.
All right. And have you had an opportunity to discuss that recommendation with your attorney?
Yes.
On the indictment ending 252, the state's recommendation is 5 serve 1, the balance probated. On indictment ending 209, 20 years to serve 4, balance probated, consecutive to indictment ending 252. And on the indictment ending 211, the recommendation is 5 serve 2, balance probated, consecutive to indictment ending 209, for a total sentence of 30 years to serve 7, balance probated. Have you been informed of that offer by the state? Sir?
I understand that.
Okay. And do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, I understand.
Do you understand that if you enter this guilty plea today, it will be permanently recorded on your criminal history?
Yes, I hear.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial? Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are, in fact, guilty?
Yes.
I'm sorry?
Yes.
How do you plead to the charges in indictment 19 SC 170209, 19 SC 171211, and 19 SC 168252?
Yes.
How do you plead, sir?
How do you plead? Guilty or not guilty, Mr. Cooper?
I plead guilty.
Okay. Is your plea made freely and voluntarily?
Yes.
Go ahead, Mr. Whitenauer.
And sir, do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Is that a yes?
Yes.
All right. Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file what is called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, sir. Your Honor, if these 3 cases were to go to trial, the state would prove beyond a reasonable doubt, starting with 19 SC 168252, that
I'm still waiting.
Hold on, Mr. Cooper. What's your question?
I want to know, is this the non-negotiable plea, right?
Correct. If you don't like the sentence, you can withdraw your plea.
Okay. Yes, ma'am.
Is that all right? Do you have any other questions about that?
No, ma'am.
Okay. And Mr. Miller explained that to you.
Yes, ma'am.
All right. Go ahead, Mr. Whitenauer.
Thank you, Your Honor. With respect to indictment ending 252, the state would prove beyond a reasonable doubt that on or about July 4th, 2018, the defendant was observed by an officer with the Georgia Department of Public Safety. And I only have the warrants in this case, Your Honor, but the facts are that observed the defendant in a vehicle with a broken windshield. The defendant failed to stop and fled from the officer. Eventually, when he was apprehended, found on his person approximately 4 ounces of marijuana. And that essentially is the basis of that case, Judge.
Okay.
With respect to indictment ending 209, the state would prove beyond a reasonable doubt that on or about June 27, 2019, an officer with the Atlanta Police Department responded to 199 Stanhope Circle, which is located in Fulton County, and spoke with the victim, in this case, Herbert Edwards, Herbert, who stated that while in a parking lot at 1218 Troy, the defendant was throwing a ball with another black male, and that at some point that ball then struck the victim's vehicle. There was no damage to the vehicle, but this victim felt that the ball was intentionally thrown at his vehicle and confronted the defendant, at which point the defendant punched the victim in the face, resulting in his 2 front teeth being knocked out. The victim in this case is familiar with the defendant because they used to work at the same location. Those are the essential facts in that case, Your Honor. And then finally, with respect to indictment ending 211, if that case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about August 25th, 2019, officers received information that the defendant, who had warrants out for assault, was at a location 1218 Joseph E. Boone. They went to that.
The assault warrants from the 209 case?
Yes, Judge, I believe so. I'd have to look back for that warrant number, which I have here, but I assume that to be the case. When they arrived at that location, 1218 Joseph E. Boone, which is located in Fulton County, they observed the defendant in front of a white SUV drinking a beer in public. They noticed when they arrived closer to the defendant, there was a bag of marijuana on the ground, which was later to be weighed at 25.6 grams. The officers then began to do some investigation going into this convenience store at that address. And while looking at some surveillance video, they observed the defendant passing marijuana to another individual that was on site. And then as she walked away, she tossed that onto the ground. Based on observing that video footage, they did charge the defendant for possession with intent to distribute, loitering, and possession of and use of drug-related objects. Your Honor, I would note
drug-related objects.
Let me look back, Judge. Your Honor, I'll have to look back more closely at the report, but I can answer that question for you in a moment. I did want to
go ahead with the criminal history.
Yes, Judge. I did want to note first that Your Honor will note that these 3 different indictments all stem from about a 2-year period, with the first being on July 4th, 2018, the second on June 27th, 2019, and then the third on August 25th, 2019. So in quick succession, he has 3 different cases involving felony charges. He does have, Your Honor, a criminal history, which includes the following: 2005, possession of controlled substance, that was for cocaine in Fulton. 2006, possession of a controlled substance, again, cocaine, Fulton. 2009, burglary, willful obstruction, possession of marijuana, felony, and theft by taking. 2009, obstruction, misdemeanor. 2010, possession of marijuana, misdemeanor. 2011, criminal trespass, which was reduced from criminal damage in the second. 2015, reckless conduct. 2017, possession of marijuana, misdemeanor. And 2018, DUI. Your Honor, it's based on that history as well as the quick succession of these new offenses that the state is recommending a total sentence of 30 years to serve 7 balanced probated with any conditions Your Honor deems appropriate.
Mr. Cooper, do you understand the nature of the charges against you?
Yes, ma'am.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, ma'am.
Has anyone made any threat or promise to influence you to plead guilty?
No, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to the right to testify on your own behalf, and the right to be represented by counsel if convicted by a jury on any appeal? Do you understand that by pleading guilty, you're giving up all of those rights?
Yes, ma'am.
Do you understand if you are not a U.S. citizen, a plea of guilty would have an impact on your immigration status?
Yes, ma'am.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
Yes, ma'am.
How do you plead to the charges, guilty or not guilty?
Yes.
Are you in fact guilty?
Yes.
Is your plea made freely and voluntarily?
Yes.
Mr. Miller, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I do, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered, and I will accept your guilty plea. Go ahead, Mr. Miller.
Thank you, Your Honor. Before the court today via Zoom is Mr. Antonio Cooper. He is 33 years old, lived in the metro Atlanta area his entire life, Your Honor. Upon being arrested for the case that ultimately had him in custody, Mr. Cooper has a newborn son. He currently is 9 months now. Mr. Cooper did not graduate high school. However, he did obtain his GED in 2017. He also obtained a forklift driver's license as well. He's been working with Aspen Refrigerating as a forklift driver for the past 5 years. He's been working full-time for them for the past 4 years, Your Honor. He does have a lengthy criminal history, Your Honor, but when it comes to the facts of the case of the indictment ending in 209, the aggravated assault, aggravated battery case, Your Honor, I did speak with the victim, Mr. Herbert Edwards, Your Honor, on several occasions. Actually, prior to even being assigned to the case, Mr. Edwards reached out to my office to inform me that he did not wish to prosecute and that it was a matter of mutual combat in which he received the worst end of it, and that he said he reached out to the officers that wrote the report as well as the victim's advocate at the DA's office to inform them of his version of the facts and his intentions to not participate in the prosecution of the case regarding Mr. Cooper, Your Honor.
Well, he doesn't really get a choice of whether he participates or not, Mr. Miller.
I did explain that to him as well, but he was adamant that he did not want to participate, but he reached out to the office to talk to the victim's advocate about his position of the matter. As they are related by family, I believe he's Mr. Cooper's. He is the father of Mr. Cooper's cousin, Your Honor. So they're very familiar with one another, and they've been trying to help any way they can. But I have informed them that they really don't have a choice in the matter of whether or not they choose to participate or not, as they could be subpoenaed. But however, with that being said, we would ask that the court would consider that and consider those facts of that case, and we ask for a probated sentence for Mr. Cooper on that case, particularly a 10-year probated sentence on that, Your Honor. When it comes to the indictments ending in 252 and 211, Your Honor, we would ask that the court sentence Mr. Cooper 5 years to serve 1 community time served, Your Honor, as Mr. Cooper has been in custody as approximately 249 days. I believe that should be at least 9 months now, Your Honor. So we would ask that he receive time served on that. And again, ask the court to consider the stance of the victim in the aggravated assault case. I did reach out also to Mr. Phil Hunter, the director of Georgia Works Program. I spoke with him yesterday. And he did say that there was a spot available for Mr. Cooper. And so I took the journey to the jail to talk to Mr. Cooper about that, to make sure that he was on board with signing up for that program, even though Aspen Refrigerating did say that they will keep his job open. Mr. Cooper did agree to submit to the Georgia Works Program. And Mr. Hunter informed me that he wanted to make sure that Mr. Cooper passed the drug test and that he would be transported from Fulton County Sheriff's Department to his facilities. And so we believe that with that in mind, we would ask for a probated sentence on all 3 cases with the condition that he participate and complete the Georgia Works Program and any other condition that the court deems appropriate.
All right. On indictment, and I will make the observation that
his record, with the exception of an 09 burglary, appears to be a controlled substance issue. He's got 1, 2, 3, 4, 5, 6, at least 7 prior convictions for drug-related charges. Mr. Cooper, I'm about to potentially give you an opportunity, but you're going to be in front of me for a long time. If you blow it, I won't have any choice but to put you in prison.
Yes, ma'am.
And Mr. Miller will tell you I won't hesitate to do that.
Yes, ma'am.
All right. All right. On 19 SC 168252, Mallory, are you on?
She is on the call, Your Honor.
Yes, I'm here. I just had to unmute myself.
That's okay. Possession of marijuana, 10 to serve 5, reduced to time served upon entry into and completion of the Georgia Works program, the aftercare program, and I'll go into the conditions of probation on all the sentences in just a minute. The fleeing or attempting to elude, 12 months. Probated concurrent, count 3, 12 months probated concurrent on 19 SC 171211 on count 5, 10 years probated consecutive to 19 SC 168252. Count 7, 12 months probated concurrent. Count 8, 12 months probated concurrent. And on 19 SC 170209 on the ag battery, 10 serve 5 on both counts concurrent with each other and concurrent with 19 SC 168252. Special conditions of all of the cases are entry into and completion of the Georgia Works program, the aftercare program. You have to be employed in school or a combination of both. You are going to have to get some kind of trade certificate in the next 2 years after you finish Georgia Works. Random drug screens for the first year, for the first 6 months after Georgia Works, it will be an 8 p.m. to 6 a.m. curfew. Same during Georgia Works, but if their curfew is more restrictive, you have to comply with that. Report to court as directed. And you'll, Mr. Miller, you'll have to get a transport order. If we've got a family member that can transport, I'm okay with that now, but it has to be a direct transport from the jail to Georgia Works with a bed space available.
Yes, Your Honor, I will submit that today.
Mr. Cooper?
Yeah.
You're done with marijuana.
Yes, ma'am.
It could have
Your Honor-
landed you in jail for a lot longer than it did. I'm going to give you a chance to get some help, but then that's it.
Thank you.
Mr. Whitenauer?
Yes, Your Honor. I was just going to ask that there also be a no contact order. I understand the victim in that case did not want to participate in the prosecution, but we would be asking for no contact with Mr. Herbert Edwards. And then also with respect to the
I'll make it
case,
a no violent contact since they're related.
yes, Judge. And then with respect to the indictment ending 211, we'd ask that he not return to the location of 1218 Joseph E. Boone.
Can't go back to that convenience store where you were selling marijuana, all right?
Ma'am.
And Your Honor, for the record, I just wanted to be clear on the indictment ending in 209. That's 10 serve 5, reduced to time served. Is that correct?
Correct. Upon entry into and completion of Georgia Works.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor,
Yes.
is it possible that we can have the sentence to say 10 serve 5 upon entry into Georgia Works and then make the completion as a special condition?
Sure, but if it's 10 to serve 5, that's a sentence. So he
Right.
can't go straight to Georgia Works. I have made it a special condition of all of the probations that he completes Georgia Works. So that is a special condition, Mallory, of all 3 sentences that he completes the Georgia Works program.
Okay, so the reduced to time served portion will be upon entry into, and then a special condition is completion of. Georgia
Well,
Works.
no, the reduced to time served is entry into and completion.
Okay,
But it's also a special condition of all of the other probations that he completes the program. What Ms. Smith is getting at is if it's a time to serve case, their position is that if he doesn't do it, he wasn't on probation. So we can't do a probation revocation. By making it a special condition of all of the other sentences, I think that covers it, doesn't it, Ms. Smith?
Yes, if you make it a special condition, if you make it a special condition that he complete the program, if he doesn't, that's considered a violation.
Okay, so that's,
okay.
and since the ag battery, ag assault, I ran concurrent. Actually, let me do that a little differently. The ag battery will tend to serve 5, reduced to time served upon entry into and completion of the program. The ag assault is 10 years concurrent with the special condition that he complete the Georgia Works program. So let me see if I can be clear. All of the sentences require completion of the Georgia Works program, but the ag assault, since it's run concurrent, will be running at the same time as the 10 to serve 5, reduced to time served. So we have that ability, if he doesn't do it, to deal with the probation revocation. Correct, Ms. Smith?
Yes, usually they'll have the sentence say 10 served 5, reduced to time served upon entry, and then leave the completion part as a special condition, because they can enter the program and that will allow them to be released. And then once they complete it.
Well, but see, if I do that, then he doesn't have to do the 5 if he doesn't complete it. And I have to go to the revocation, which is why I'm structuring it that way.
Okay.
So the ag assault charge, you want 10 years probated concurrent?
Correct, with completion of the Georgia Works, entry and completion of the Georgia Works as a special condition.
Okay.
All right? Are we good?
I think I'm good.
I believe so.
Thank you.
All right, thanks, Ms. Smith. Appreciate your input. All right, are we ready on, what do we want to do? Teasley?
Yes, Judge. I think that's what's ready.
And Your Honor, that concludes my business today. Can I be excused?
No, you have to stay the whole day.
The whole day?
The whole day, just for fun, because we enjoy seeing you in the court.
How lucky am I?
Of course, go have a
One
good,
thing for the client, for the defendant.
yes. Go ahead, Ms. Smith.
He would need to
Thank
report
you, Honor.
within 48 hours upon his release, either on a Tuesday or Thursday at 8 a.m.
I'm gonna give him 96 hours only because he's got to go straight to Georgia Works. So it'll be a Tuesday or Thursday, 4 days, Mr. Cooper. After you get to Georgia Works, you have to be at probation.
Your Honor, I believe Mr. Cooper stepped away. I do
Will
not
you
believe
get a hold
this.
of him, Mr. Miller?
Yes, Your Honor.
Okay, great. All right, go have a good weekend, Mr. Miller.
Thank you, Your Honor. See
All
everyone
right.
later.
Do
Bye,
we have,
Terrence.
is this Mr. Teasley we have?
Yes.
All right, you're gonna have to speak up if you want to leave your mask on, Mr. Teasley. Or
Yes,
you can
ma'am.
pull it down right in front of your face. That's up to you, but there you go. That's perfect. You don't have to pull it all the way down. Can you hear me?
Yes, Your Honor.
I'm Sean LaGrua. I'm the judge handling your case today, all right?
Yes, Your Honor.
Now, Mr. Shive's on with us. I assume you've had an opportunity to speak with him.
Yes, Your Honor.
And he's gone over the plea sheet with you and the indictment.
Yes, Your Honor.
Okay, you have a right to be here in the courtroom if you want to be, but right now the sheriff's department is not bringing anybody to the courthouse because of the COVID. Are you okay proceeding via computer on Zoom?
Yes, Your Honor.
All right. The other thing that happens is when you come into the courtroom, if you were here, you would have to sign the indictment and the plea of guilty form, okay? Obviously, you can't do that this morning because you're there and I'm here. Are you comfortable letting me sign an initial for you?
Yes, Your Honor.
Mr. Scheib, are you comfortable me signing for you on the indictment and the plea sheet?
Yes, Your Honor. And just to let you know, I have faxed to, or we have emailed to you 3 documents I have in reference to plea form. I have my client, I went to the jail and spoke to him and had him sign it. So we sent a copy of that to you as far as the plea form. We sent a copy to you as far as him waiving certain rights, and he signed that on the.
Oh, fantastic.
Okay.
Are you okay proceeding on a copy of the indictment?
Yes, Your Honor.
Yes, Your Honor.
Okay, go ahead, Mr. Whitenauer.
Actually, it's Sue Chan, Your Honor.
Okay, Ms. Chan. Okay, go ahead.
All right, Mr. Teasley, if you could please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your true, correct, and legal name?
Orenthal Ramon Teasley.
Okay. And can you just spell it for the court reporter, please?
Orenthal, Orenthals, Ramon, Raymond, Teasley, Teasley.
Okay. And Mr. Teasley, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I am not.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
39 years old. I have graduated.
You graduated from?
High school.
Okay. Are you able to read, write, and understand the English language?
I am. Okay.
Do you understand that you are charged with the following offenses? In indictment number 20 SC 174719, count 1, possession of heroin with intent to distribute. Count 2, possession of MDMA with intent to distribute. Count 3, possession of cocaine with intent to distribute. And count 4, possession of methamphetamine with intent to distribute. Do you understand you're charged with those offenses?
Yes.
Your Honor, as for the remaining counts, the state would have a motion as part of the plea agreement, but we can address that later. Do you understand that you have the right to plead?
What's the motion if the plea goes through?
If the plea goes through, the motion would be to null pros counts 5 through 9, Your Honor.
Okay, go ahead.
Thank you. Do you understand, Mr. Teasley, that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Okay. Have you had enough time to speak with your lawyer, Mr. Scheib, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with Mr. Scheib?
No.
Are you satisfied with his services?
Yes.
Mr. Scheib, do you waive formal reading of the indictment?
We do. And just let me interject one thing. We are waiving a lab report in reference to this. I normally want a lab report. I spoke to my client and he's waiving the lab report also. So as far as counts 1 through 4, we are stipulating that in fact, under the accusation or indictment, that the different counts, they articulate heroin, MDMA, methamphetamines, and cocaine. My client is stipulating that in fact, those are drugs. And we waive a lab report.
Okay. And Mr. Scheib, do you waive any and all defects in the indictment, including any with respect to the name?
Yes, ma'am.
Okay. All right. Back to Mr. Teasley. Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to? And let me go over them, Mr. Teasley. For the possession of heroin with intent to distribute, that's 5 years to up to 30 years. For possession of MDMA with intent to distribute, that's 5 years to up to 30 years. For possession of cocaine with intent to distribute, 5 years to 30 years. And possession of methamphetamine with intent to distribute, 5 years to 30 years. Has your attorney advised you of those sentences?
Yes.
Okay. And Mr. Teasley, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of, on count 1, the possession of heroin with intent to distribute, it's 15 years, served 5 years, commuted to time served with a balance of 10 years on probation. On count 2, possession of MDMA with intent to distribute, that's 15 years, served 5, commuted time served, balance of 10 years on probation. On count 3, possession of cocaine with intent to distribute, 15 years, served 5, commuted to time served, balance of 10 years on probation. And count 4, possession of methamphetamine with intent to distribute, 15 years, served 5, commuted time served, balance of 10 years on probation. All 4 counts are recommended to be concurrent. Do you understand, however, Mr. Teasley, but that the court does not have to accept that recommendation?
Yes.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other? Do you understand that, sir?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that neither the court, your attorney, nor the district's attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, that's 1 year to 5 years, or use a firearm in a crime, that's 15 years consecutive, and you'll be guilty of felony, which may carry a sentence of 1 year to 15 years in prison. Do you understand that, sir?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand those rights, sir?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Okay. All right. And all right. And how do you plead to the charge of possession of heroin with intent to distribute in case 20 SC 174719?
Guilty.
How do you,
Mr. Teasley, how do you plead to the possession with intent of possession of heroin, MDMA, cocaine, and methamphetamine in this indictment? Guilty or not guilty?
Guilty.
All right, go ahead.
thank you. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for these felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Judge, had this case gone to trial, the factual basis was that on January the 18th of 2020, Fulton County Police were investigating possible human sex trafficking occurring at the Knights Inn located at 4330 Fulton Industrial Boulevard in Fulton County. At the hotel at room 520, the door was ajar and a strong smell of marijuana emanated from the room. Police knocked and identified themselves and heard the occupant say, "Come in." Inside, the police observed the defendant sitting at a table rolling a marijuana joint. Police told the defendant they did not care about the joint he was rolling. The defendant opened the door further. Police saw what they suspect to be other narcotics in plain view, wrapped in clear sandwich bags on a bed behind where the defendant had been sitting. The defendant tried to close the door on police who were attempting to detain him. The defendant was eventually tased by police and then placed in custody. Police recovered from the table where the defendant had been sitting a scale, small Ziploc bags, along with about what they weighed to be 27 grams of crack cocaine, 21 grams of powder cocaine, 13.7 grams of heroin, 26.5 grams of meth.
Wait, go back a minute. How much cocaine?
It was 27 grams of crack cocaine and 21 grams of powder is what they weighed it at.
Together, it would have been a trafficking amount.
It would have.
Go ahead.
Unfortunately, we when I last checked with the GBI, there was no lab. It hadn't even been assigned out for testing.
Okay, go ahead.
Okay. The 13.7 grams of heroin, 26.5 grams of meth, 17.1 grams of ecstasy, 1 oxy tablet, and about 3 ounces of marijuana.
Let me make sure I have this correct. You're recommending a time served after 3 months on a case that has trafficking in arguably at least 2 of these cases.
We are, Your Honor.
Not happening.
Okay.
Mr. Scheib, do you want to go forward?
We'd like to go forward with what's in the accusation. We don't have a lab report, so a lot of times, Your Honor, several things will happen when the police weigh it. They'll weigh it with the bag, or the.
Well, I get that, and I get it may not come back as trafficking, but this still is not a time served case.
Well, and just to let the court know, he does have a record, and I was looking at it as they were going over this. Most of them are all for marijuana. You go back 20 years in their drug cases, 2001 marijuana, there's a cocaine in 2003 and 2005, marijuana, to 2011 marijuana, 2018 marijuana. And just to let you know also, this was a hotel room, and I understand there were several other people involved that weren't there, and it wasn't even registered to his name. And
we can go through with the plea, but it is not, I can tell you right now, with that record and this amount of drugs, it is not a time served case. Not with me.
Okay. What is, and every court's different. What are you looking at as far as talking jail time?
I haven't decided.
Okay.
But
Well,
I mean, he's got possession of heroin, MDMA, arguably trafficking in cocaine. Mr. Scheib, how long have you known me? A long time. Okay, don't
20,
say it. Don't
20.
say it. But I get that oftentimes when the police weigh the drugs, they don't come back exactly, and it may not come back as trafficking. It's still not a time served case.
Okay. And just to let the court know, I was partially retained to do a preliminary and a bond. And in the spirit of trying to move this along and because of what's going on and everything, I told them that I would do this. And quite frankly, they paid me $1,000 to do the preliminary and bond, not even, and we did an entry on this thinking, and I understand the court's position. We did an entry on this thinking that we could work something out because we didn't have a lab report and because of the difficulties moving forward with anything right now.
I think my ADAs and all would tell you I'm being much more what's the word, Mr.
Flexible.
White?
Flexible, Your Honor.
Right now than I might otherwise be. This goes well beyond my flexibility. That's a good word, Mr. Whitenauer. Thank you.
And I know my client, his girlfriend, who is, like I said, partially paid me. She was pregnant at one point and lost the baby. So I know, and know he's got 4 children, but I don't think he's on probation or parole. But most of these cases, Your Honor, well, like I said, are marijuana. And I don't know what the lab results is going to come back and say, because I know that 1 or 2 things happen. They weigh them with the bags and they don't use calibrated scales when they go ahead and do this. So, I mean, I don't know.
And I understand that. And I'm not saying that this is going to come back as a trafficking case. I get it may not. But
Right.
with the 4 of the most serious kinds of drugs, all at decent weight, regardless, it's not a 3-month case, in particular with his record.
Right.
We can go through and I can sentence him, and if he wants to withdraw it, he can.
Okay.
But I
Yeah.
just thought I'd put out there on the front end.
Okay. You understand, Mr. Teasley, what the judge is saying? The judge is thinking about, well, prison time, not just straight probation. And if the judge goes ahead with this, we go ahead and the judge gives you something that you do not like, you do not think's fair or whatever, you can withdraw your plea. You understand that?
Yes. Can I speak, Your Honor?
Mr. Scheib,
Go ahead.
go ahead.
I just want to say that the situation at hand, like the hotel room, it wasn't even my room. I just so happened to be there by chance. I just so happened to be there by chance. I actually had nothing to do with the whole situation. I just so happened to just.
Okay, now wait, now stop. We're entering this.
That's why I
plea.
asked you, Mr. Scheib.
No, I knew what he was going to say in reference to that, and I
Okay.
articulated the same thing. But that's all you need to say, Mr. Teasley. I think you're doing this because you believe it's in your best interest, because actually we could have a jury trial and the jury could come back and they could convict you. And based on your record, if you were convicted, the judge would have no choice but to give you the full amount, and which means you would serve life in prison without parole, the way I'm looking at this. And they could run it as consecutive as far as the different times, 15 years. The judge could actually give you approximately 60 years in prison without
Oh, no,
parole.
they're 5 to 30. So
You would have to give the max.
30.
You would have to give the max based on the fact that he would be a recidivist with at least, I think, 5 felony convictions. So you would have to give him the max under.
it's a potential 120 years.
Right. Thank you. I was thinking at 60. No, you're correct. So Mr. Teasley, that you would be facing that. So we could go forward with this and the judge could pronounce her sentence and you could decide if you want to take it or not. If you don't want to take it, you withdraw it and you'd end up having to have a jury trial and you'd face a life without parole. So you want to.
Do you want to go through it and decide if you want to withdraw it? And if you do, then you can talk to Mr. Scheib further.
Yes, Your Honor.
All right. Do you understand the nature of the charges against you?
Yes, Your Honor.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, Your Honor.
Has anyone made any threat or promise to influence you to plead guilty?
No, Your Honor.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, and the right to appeal your case and be represented by counsel if convicted by a jury? Do you understand that by pleading guilty, you're giving up all of those rights?
Yes, Your Honor.
Do you understand if you are not a U.S. citizen, a plea of guilty could have an impact on your immigration status?
Yes, Your Honor.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
Yes, Your Honor.
How do you plead to the charges, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty because it's in your best interest to plead guilty and you're afraid if you go to trial, you might face more significant consequences?
Yes, Your Honor.
Is your plea made freely and voluntarily?
Yes, Your Honor.
Mr. Scheib, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
Yes, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea. Go ahead, Mr. Scheib. Anything else?
No, Your Honor, I've articulated, I think, everything I need to.
Count 3. 30 to serve, reduced to time served upon entry into and completion of a minimum 9 to 12 month inpatient drug treatment program to be approved by the court. Count 1, 30 years probated consecutive. Special condition of that probation is that you successfully complete whatever program is approved by the court. Count 2, 30 years probated concurrent with count 1. Count 4 is 30 years probated concurrent with count 2. Special conditions of all of the probation is completion of an inpatient drug treatment program to be approved by the court, random drug screens. You have to be employed in school or a combination of both. There would be a 10 p.m. to 6 a.m. curfew for at least the first year after you're out. 240 hours of community service. And I want the record to be clear. The only reason I'm giving you this opportunity is because of the state's initial recommendation on this case.
Yes, Your Honor.
Mr. Scheib?
I'm just looking at it. Yes, Your Honor. Is there a chance that you can mute what you hear and I can speak?
Mallory, can you put them in the breakout room?
Yes, I think the host has to do it. I think Shirley's on and she can do it maybe.
Well,
Yes.
let me ask you this.
We
Mr.
can put you on Zoom with him by himself.
Okay, can we just have a minute or two on that?
Yeah, and we won't be able to hear what you're saying.
Okay, thank you.
Who's the host?
Here she comes.
I'm working on it right now.
Okay, can you put Mr. Scheib and Mr. Teasley in a breakout room for us?
Yes, ma'am.
All right, and we'll go on with the next one. Mr. Scheib, just how long do you need?
Just a couple minutes. Well, first of all, let me ask my client, because he knows the system. Do you want to take this? As the judge stated, she's not offering no prison time that I'm aware of. It's just a drug rehab, which on the record I would put is a very good scenario when you're facing life without parole. And to be very candid, I know Judge LaGrua's, we go back 20 years, and she's a tough sentencing judge. I'm gonna be straight up about it. So you take a chance if you have a jury trial and you lose, you're going to prison for a long time. And the judge doesn't have any recourse. Do you want to take it as it states, as the judge stated? Pardon me?
Yes, I just want to ask what inpatient program would I be taking?
Mr. Scheib's going to have to work with maybe the PD's office, social worker to find one. There's a whole bunch. There's Stan, there's Trinity House, there's Better Ways is a good one. There's a whole bunch of them. You may have to wait a month or so, maybe even 2 to get in, because right now they're not taking folks because of COVID. But I know Stan's starting to open back up.
Yes, and that's the only one that I'm aware of currently. And I stay in contact with Ms. Cole, but Stan is currently taking folks, just not bed space yet, but we're hoping that'll be soon.
Okay, and he would basically wait in jail until they have an opening.
Correct, and it would have to be a program approved by me, because there's some crazy programs out there that we've not had good luck with.
Okay.
But most of the standard programs I approve.
Okay.
And
is that
would
okay?
have to report to court as directed.
Okay. Okay. You understand that, Mr. Teasley?
Yes.
Okay. And that's what you want to do?
Yes.
Okay.
Mr. Teasley, let me explain. This is a gift. A big gift, all right? So if you mess this up, you're not going to give me any choice. All right?
Yes, ma'am.
All right. Good to see you, Mr. Scheib. Thanks for checking on us.
Okay, thank you. Take care.
Ms. Smith, did I do that right? I think.
Yeah, what was your question, Your Honor?
Did I do that one right?
Yes.
Okay.
Fantastic.
And just to let Judge know, I'm going to file a motion to withdraw under the DeSantos case. I'm sure you're aware of it. When we finish with something, the Supreme Court has advised lawyers to file a motion to withdraw, because if not, he's on probation for 30 years. It could be 10, 15 years down, and he has a probation.
Understood. Just make sure he understands his rights before you withdraw.
Okay. We'll send him the necessary documents and everything.
Okay, fantastic.
And
All right,
is he
good
still
luck,
on?
Mr. Teasley. Yes. Who's,
Mr. Teasley is still on?
yes?
Okay, he would just need to report to probation within 48 hours upon his release.
I'm going to give him 96 since he's going straight to the program.
Okay.
All right, Mr. Teasley, within 4 days, business days of when you get to any program, you have to get in touch with probation.
Yes, ma'am.
All right?
Yes, ma'am.
All right, if you have any questions, call Mr. Scheib as this plays out. Mr. Scheib, as soon as you find a program, let me know. Oh, here's the other thing, Mr. Scheib, I should tell you. The jail has quit doing transports to programs. I will approve a stable family member or friend that guarantees that they will take him straight to the program when there's bed space. It will be a violation of the condition of his probation if he's not at the program within an hour of his release from custody.
Oh, okay. Okay.
All right. So Mr. Teasley, if for some reason they let you out of custody, you better call Mr. Scheib and get him to get in touch with me. Otherwise, you're going to be in violation of your probation.
Okay.
All right. Good luck.
Thank you. Thank you, Judge. Have a nice day. Thank you.
You too. Good to see you. All right. What else are we ready on?
We're ready on position 10, Judge.
Position 10. Samathi Isvaradivan.
Yes, Your Honor.
How do you pronounce that?
You pronounced it correctly, Your Honor.
Okay, great. Go ahead. Is this Mr. Poole again?
Yes, Judge.
Hey,
And
Mr. Poole, I was wondering why you were still on.
yes, I have this case and another case for a plea, Judge.
Okay, go ahead.
But this case, Judge, I would ask the court
Well, hold on, let me back up. Ms. Isvaradivan, you understand that we're handling this via Zoom. Are you okay with that?
Yes, Your Honor.
And have you had a chance to talk to Mr. Poole about that?
Yes, Your Honor.
All right, go ahead, Mr. Poole.
Judge, my client's been in custody since February the 12th of 2018. She was initially booked in 2017, but she posted bond about a couple of weeks after. And there was a bond revocation, which, you know, put her back in custody. I requested that Dr. Norman evaluate her. Dr. Norman said that she was not competent. She was sent to Georgia Regional. Georgia Regional issued a report dated March the 19th of 2020. I provided a copy of that report to the DA's office and to the court assigned to this particular indictment. In that report, it says that she is not competent. She is not likely to be restored. And they also found that she does not meet the criteria for civil commitment.
Mr. Poole, I hate to tell you, and I hate to be difficult, but this is going to need a full-blown hearing. This one can't just be done with Zoom, because at least with me, I'd require the doctor to testify.
Okay.
I have found generally that we get these reports, they're not civilly committable as long as they stay on their medication, but the doctors also say if they go off their medication, what's her criminal history? They're a danger to themselves and others. What's the criminal history? And I don't have a copy of the report.
In the report, she doesn't have, from my review of the report, I don't believe she has a criminal history, but I would just defer to probation. I understand the court has already said that it would need to hear from a doctor, but
Well, I don't even have the report.
well, I don't want to waste the court's time. I could tell the court what's in the
Well, I don't think
report, or
you're
I could just
wasting the
ask for it
court's
to be
time.
rescheduled. I could just ask, you want me to just have it scheduled?
I'm
at
gonna
some
have it.
later date?
I'm next, Mallory, aren't we on again next Friday?
No, we have Wednesday. I think we switched.
We're on
Yes,
Wednesday. If I can get the report and at least have something to review, Mr. Poole, I might be able to consider it after hearing from the DA. What's the DA's office say? Who's on for them?
That's me, Your Honor. This is Meredith Fortuna for the state. I just recently acquired this case. I was just assigned to the CUAC unit, so I have not gotten a copy of the report. I've got to track it down to find out who it was sent to. It would be our position that the defendant remains in custody until there is a full-blown civil commitment hearing, which is, I think, what the statute requires. So we would request a hearing on it. That may change if I look at the evaluation, but at this time we would ask for a hearing.
Can you, by next Wednesday, get a copy and get me a copy of, or Mr. Poole, you can get us a copy of the evaluation and the underlying facts of the case, and I'd be happy to look at it, Mr. Poole. I'm not saying no, but I don't have anything now, and the state doesn't have anything.
Well, actually, I understand that this particular prosecutor said she didn't have anything, but when the report first came out, I emailed a copy of the report to Ms. Ferguson with a dead docket order. And according to the email that I'm looking at right now from Ms. Ferguson, which I could provide to the prosecutor present today, there was not an objection from the state to the dead docket order that I presented, that I drafted and emailed to the state. So, but I will just ask if it could be reset.
Do you want me to put it on Wednesday? Can we get our ducks in a row by then, Ms. Fortuna?
Yes, Your Honor.
Mr. Poole?
That's fine, Judge.
Okay, Ms. Esvaradivan, we're gonna put this back on the calendar next Wednesday, all right?
Okay,
See
thank
if
you.
we can get the information we need.
Thank you, Your Honor.
In the meantime, I would also get a hold of the victim in the case
Yes, Your Honor.
and see what we need to know. Mallory, can you make sure this gets on?
Yes, I will.
Okay, all right, and you have, it looks like you have two, Mr. Poole. I show you having Ulysses Howard and Calvin Cooper.
Judge, that's the same individual.
Oh, okay.
Yes.
Two different cases, one person.
Correct.
Can we go ahead and proceed so we can get Mr. Poole done?
Your Honor, that concludes my business. May I be excused?
You may. Who do we have? Who's here on the screen in 4 North? Is this
Position number 8 and position number 9 is the same person, just alias.
Okay, who's the DA?
Alice Holloway, judge for the state.
Okay, all right. Is it Mr. Howard or Mr. Cooper?
Howard.
Okay, so your true, correct, and legal name is Ulysses Howard. Is that correct?
Correct.
Okay, can you pull your mask just below your mouth for just a few minutes so we can hear you? It's hard to hear you with that in front of your mouth, okay? My name's Sean LaGrua. I'm the judge handling these cases today. Have you had an opportunity to talk to Mr. Poole about your cases?
Yes, ma'am.
Okay, has he gone over the indictment and the plea sheets with you? I'm sorry?
Yes, ma'am.
Okay. You understand that you have a right to be here in the courtroom if you want to be, but right now the jail is not transporting folks to the courtroom. Are you okay dealing with it over Zoom, the computer system?
Yes, ma'am.
Okay, and are you okay? You can't be here, obviously, to sign the indictment or the plea sheet. Are you okay with me initialing them and signing them on your behalf?
Yes, ma'am.
Okay, and Mr. Poole, are you comfortable with me signing on your behalf? And are you waiving proceeding on the copies of the indictments?
Yes, as to both questions, Judge.
Okay, go ahead, Ms. Holloway.
Okay. Mr. Howard, would you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter before this court will be the truth, the whole truth, and nothing but the truth? Would you please state and spell your name for the record?
Ulysses Howard. Ulysses Howard. ULYSSES. Howard, HOWARD.
Thank you. And are you the Ulysses Howard that was indicted in 20 SC 175000?
Yes.
Are you also the defendant known as Calvin Cooper, indicted in 19 SC 172346?
Yes.
Okay. Mr. Howard, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not been given today?
Yes.
What medication is that?
Abusing and Risperdal.
And you have not been given that today?
No, ma'am.
Do you think that the lack of that medication will affect your ability to understand and participate in these proceedings?
Not at all. Not at all.
Okay. How old are you?
51.
I'm sorry, Mr. Howard, you're gonna have to get closer to the microphone and speak clearly for me, okay? We're having trouble hearing you.
51.
Thank you. And how far have you gone in school?
10th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that in indictment number 20 SC 175000, you're charged with possession of cocaine and possession of drug-related objects? And in 19 SC 172346, you're charged with entering automobile.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney, Ronnie Poole, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
Do you waive formal reading of these indictments?
Yes.
Do you waive any and all defects in these indictments, including any with respect to your name?
Yes.
And have you been arrested on all of these charges?
Yes.
And the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
You don't need to ask that question.
Thank you. And has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to?
Yes.
Do you understand that possession of cocaine has a minimum of 1 and a maximum of 8 years? Possession of drug-related objects has a minimum of a day and a maximum of 12 months. And entering automobile has a minimum of 1 year and a maximum of 5 years.
Yes.
And do you understand that this is a negotiated plea of guilty, where the state is recommending to the court a sentence of 5 years with the first 1 year to serve, commuted to time served, with the special condition that you enter and complete the Someone Cares program?
Yes.
Okay. Do you understand that if you're currently on probation or parole, it could be revoked based on your entering a guilty plea today?
Yes.
And do you understand that if you're placed on probation, you can't violate the criminal laws of any government unit or special condition of probation without being subject to revocation for the balance?
Yes.
And do you understand you're not allowed to possess or use a firearm while on probation? I'm sorry?
Yes.
All right. Mr. Howard, are you a United States citizen?
Yes.
Do you understand there may be other adverse or unfavorable consequences of a guilty plea? For example, this plea may affect your right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or to obtain employment.
Yes.
And do you understand that you waive any and all defenses, including mental health defenses, by entering a plea of guilty?
Yes.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel at a trial, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No. No, ma'am.
Sorry?
No.
Okay. How do you plead to the charges of possession of cocaine and possession of drug-related objects in the indictment ending in 000 and entering automobile in the indictment ending in 346?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you may have only a limited right to appeal this guilty plea conviction?
Yes.
And do you understand you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to
Yes.
file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And Your Honor, had the case proceeded to trial, the state would expect to prove beyond a reasonable doubt that in 20 SC 175000, officers were on patrol at 241 Forsyth Street on February 7th of 2020 and viewed Mr. Howard along with his co-defendant, Mr. Craig Sams, holding a crack pipe. Officers asked the defendant, Sams, to hand the officer the pipe, which Mr. Sams did. On the ledge where the defendants were standing, officers located a small piece of cocaine. Defendants were placed under arrest, and in defendant Howard's pocket, officers located a red baggie with cocaine residue, and both defendants were charged. And then in indictment number 19 SC 172346, the state would expect the evidence to show beyond a reasonable doubt that on October 10th of 2019, officers responded to a liquor store at 595 Ralph David Abernathy Boulevard in reference to a vehicle being broken into. The officer spoke to Ernest Quarles, who reported that he had parked his car, a 2014 Nissan Sentra, in the parking lot at the location at around 10 p.m. the night before because his car had a flat tire. But when he returned at around 10 a.m. the next morning, the passenger side window had been broken and it appeared that someone had been inside the vehicle. Officers went into the package store at the location and watched the security footage from the incident, and it showed that around 12:14 a.m., a male who was later identified as the defendant threw an unidentified object at the vehicle, breaking the passenger side window. He then went into the vehicle through the broken window and appeared to be going through the vehicle. He eventually climbed out of the broken window and took clothing and concealed them in a bag along with $5 in coins belonging to the victim. At around 8 p.m. that night, the liquor store called the police again because the store clerk had recognized the same suspect that broke into the car. The officers arrived and the defendant was wearing the same clothes he was wearing when he broke into the victim's car on the footage. So he was arrested and charged. And then in regards to the defendant's history, he does have 11 prior felony convictions. The most recent was a 2007 violation of the Controlled Substance Act in Cobb County. Then a 2005 possession of a firearm by a convicted felon and possession of cocaine in Fulton County. Before that, there was a 2008 burglary in Fulton County. There was a controlled substance violation in 1994 in Fulton County, a theft by receiving in Fulton County in 1994, a theft by receiving in Fulton County in 1991, a Controlled Substance Act violation in 1989, a dangerous drugs conviction in DeKalb County in 1989, a theft by receiving in DeKalb County in 1993, a theft by taking in Cobb County in 1997, and a theft by taking in Cherokee County in 1998. So the state would just ask that you accept the negotiated plea to the 5-serve-1 commuted to time served with the special condition the defendant enter and complete the Someone Cares program.
What is the Someone Cares program?
I'll let Mr. Poole sent me the brochure, but I can let him explain. Or
it's a program. They have 3 different offices. One's in Marietta. They have one here downtown in Atlanta and another one in Tyrone, Georgia. Basically, it's a place for him to get treatment for substance abuse and mental health. I reached out to someone at the program this week. It would not cost him anything. According to the email that I received this week, he would basically just have to call to make an appointment. They provide, again, like I said, treatment for substance abuse and mental health. They have access to, of course, social workers that have doctorate degrees, education counselors, social workers with master's degrees. He doesn't have any like medical problems, but if he did, they would have doctors that could help him, and nurses as well.
Have you used the program before?
No, I have not used this program before, but I reached out when we were trying to get the case resolved. Since I didn't think the jail would be transporting to programs, I reached out to the social worker assigned to the courtroom that I'm in, Vanessa Scott, and I asked her if there's a program that she had used before, where if he's released from custody, he could report to the program and get treatment on an outpatient basis. And Ms. Scott sent me this brochure, and I emailed it to Ms. Holloway and asked her if this would be something that she would accept as a form of treatment. And she indicated to me that she would.
Mr. Howard, do you understand the nature of the charges against you?
Yes, ma'am.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, ma'am.
Has anyone made any threat or promise to influence you to plead guilty?
No, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, and the right to appeal your case and be represented by counsel if convicted by a jury? Do you understand that by pleading guilty, you're giving up all of those rights?
Yes, ma'am.
Do you understand that if you are not a U.S. citizen, a plea of guilty could have an impact or would have an impact on your immigration status?
Yes, ma'am.
Do you understand that the court's not bound by any promises, recommendations, or reductions, that I could sentence you as I deem appropriate?
Yes, ma'am.
How do you plead to the charges, guilty or not guilty?
Yes.
Are you in fact guilty?
Yes.
Is your plea made freely and voluntarily?
Yes.
Mr. Poole, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
Yes, Judge.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered. And I will accept your guilty plea on indictment 19 SC 172346, 5 served 2 reduced to time served upon entry into and completion of the Someone Cares program. Indictment 20 SC 175000, 8 years probated consecutive to 19 SC 172346, 12 months probated concurrent on count 2. Special conditions of both probations are completion of the Someone Cares program for at least 6 months. You will report to the Someone Cares program within 24 hours of your release. That is a special condition. If you don't, it will be a violation. Random drug screens, an 8 p.m. to 6 a.m. curfew. And the only reason I'm willing to do this is because it's been 12 years since his last conviction. Looks like he's got a drug problem. You need to get it addressed, Mr. Cooper. All violations report back to me. So you're gonna have to see me again, Mr. Cooper, if you don't do what you're supposed to do, all right? Now, let me explain something, Mr. Cooper. If you get to Someone Cares and it's not enough help for you, All you have to do is call Mr. Poole and he'll get you back into court and we'll find a better program, all right? But don't come back on a violation. Can you hear me? All right, Ms. Smith, 48 hours.
Yes, Your Honor. Is there a time frame pending on the defendant reporting to the program? Is there a wait
24
time?
hours within his release.
Okay, and I think he has an active probation case because we're showing him as
Hold on, Mr. Cooper, or Mr. Howard, I'm gonna let you answer. Go ahead, Mrs. Smith.
we're showing him to have 2 different profiles in our system.
How much time's left?
2 years, 1 month, and 18 days.
Are you waiving, Mr. Poole?
Yes, Judge.
Revoke the balance reduced to time served upon entry into and completion of the Someone Cares program. Go ahead, Mr. Howard. What's your question?
Yes, I just recognize that you said it would be 8 year probation on this, what I'm being out for today. And it was my, it was brought to my acknowledgement. I thought it was gonna be 4 years. You said 8 years.
Well, you're gonna have to have more than that to make sure you complete the program. If you want to withdraw your plea, you can.
No, I'm not gonna withdraw it. I'm just question that I wanted to ask.
Just want to make sure you're not going to have to be on probation that whole time if you do what you're supposed to do. All right? All right.
Judge,
Anything else? Yes.
could I ask a question?
Sure.
I understand that the court has said, and I'm sure it will be on the disposition sheet, that he's to report within 24 hours of being released. This is probably overkill, my next request. Is there any way to put on the disposition sheet that no transport order is required?
Sure.
All right, thank you.
And this won't get filed till Monday anyways, so it'll be during the week where he can report. So we're not going to get a situation where they let him out on a Saturday or Sunday morning and he can't go.
Thank you, Judge.
All right. Good luck.
Report date,
Go ahead, Mr. Smith, Miss Smith.
I'm sorry, his report date would be 5/28.
Okay, did you hear that, Mr. Howard? 5/28, May 28th, you have to report to probation.
At 8 a.m., 5/28 at 8 a.m.
All right?
Yes.
All right. Go ahead, Mr. Poole.
Judge, that was my last matter. May I be excused?
You may. Good to see you. Have a good weekend.
And Judge,
You
that
too.
was also,
You too.
sorry.
Bye.
Judge, that was also my last matter. May I be excused?
You may. Have a good weekend.
You too. Thank you.
All right.
Your Honor, we have position number 7, Mr. Dixon. Position number 7, Mr. Dixon.
Okey doke. Let me find paperwork.
Tanya, don't look so happy.
I'm just trying to figure out, technology is not my thing some days.
You and me both. Why do I not have? I don't have an indictment on Mr. Dixon. Hold on. Maybe it got behind something else.
Did I miss one?
Yeah, can you send it to me? Can y'all give me about 2 minutes? Let her send it and let me go get it.
Yes, Judge.
I have Harper and Graves, though it looks like I also may be missing a Harper.
One Harper is a probation revocation.
Okay, got it. That's why. All right. And I have Graves, but I need
Check.
Dixon. Yeah, I need Dixon.
All right. I think he was on. Okay, I'll send it.
Okay, give me 1 minute, okay, guys?
All right, let's go ahead.
Your Honor, this is State of Georgia versus Devin Dixon. It's 18 SC 157610. Defendant will be entering a plea today to the indictment. Ms. Jones, correct me if I'm wrong, but we are going forward on a negotiated plea.
Yes.
All right. Sir, can you hear me?
Yes, sir.
All right. If you can,
Oh,
please.
sorry, hold on. Hey, Mr. Dixon. I'm Sean LaGrua. I'm the judge on your case. Can you hear me?
Yes, ma'am.
Okay, can you pull that mask down just right below your mouth so we can hear you? Have you had an opportunity to speak with Ms. Jones about this case?
Yes, ma'am.
Has she gone over the indictment and the plea sheet with you?
Yes, ma'am. She had let me know that it'll be getting dropped to a simple battery for 24-month probation or misdemeanor.
Well, hold on, we're not there yet. You're getting ahead of me.
Oh,
That's all right. You have a right to be here in the courtroom, but right now we're not bringing defendants to the courtroom because of COVID. Are you okay with proceeding by this computer?
Of course, no problem.
All right, and are you okay since you can't sign the indictment and the plea sheet? Are you okay with me initialing those for you?
Yeah.
And Ms. Jones, do you waive proceeding on the copy of the indictment?
So waived, Your Honor.
Okay, go ahead, Mr. Whitenauer, sorry.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to ask you some questions. Please respond out loud, yes or no, so that the court reporter can take down everything that we say. Agreed? All right. If you
Speak
would
up
please,
for me a little bit.
Yes, sir.
if you would please raise your right hand. Do you swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, if you'd lower your right hand and please state and spell your true, correct, and legal name.
Devon Dixon, D-E-V-O-N, last name Dixon, D-I-X-O-N.
All right, sir, at this time, are you taking or under the influence of any alcohol, drugs, or medication?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you?
30.
And how far have you gone in school?
Graduation.
High school?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you're charged with the following offenses in indictment 18 SC 157610, count 1, aggravated assault, and count 2, cruelty to children in the 3rd degree?
Yes, sir.
Understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And sir, have you had an opportunity to speak with your attorney about the waiver of rights form?
Yes, sir.
And did your attorney go over with you each of those items on that form?
Yes, sir, she did.
All right. And do you have any problem with the judge initialing that form for you today since you can't be in court?
No, I do not.
All right. And sir, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss the case with your attorney?
No, I do not.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment?
Yes.
And sir, has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to today?
Sir.
I'm sorry?
Yes, you have.
All right. And Your Honor, we are offering a reduction on count 1 to battery family violence. Sir, that charge carries a maximum of 12 months in confinement, and we are going forward on count 2 as indicted, cruelty to children in the 3rd, which, sir, carries a maximum of 12 months in confinement. Do you understand?
Yes, I do.
All right. And sir, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court that you be sentenced on count 1 to 12 months of probation, that you complete the family violence intervention program, have no contact with the victim, that you be employed or in school, that there be a curfew, that you consume no drugs or alcohol, you be subject to random screens, and on count 2, that you be sentenced to 12 months probation consecutive to count 1 with the same conditions, as well as any other conditions deemed appropriate by the judge. Do you understand?
Yes, sir. My question is it going to be just 12 months probation, or would it be a total of 24?
The negotiation that we've had with your attorney is that would be a total of 24 months on probation. Sir, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir. But I do have one more question, if you do not mind asking, about the curfew time. Is it necessary that I have a curfew? Because I work and I will be going back to work, and I was trying to figure out, is there any way that I can get uplifted off a curfew?
We can
Sir,
address that when it comes to our side, okay?
All right, thank you.
Sir, do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, I do.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, I do.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, I do.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses called against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, they have not.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
And sir, how do you plead to the charge of amended count 1, family violence battery, and count 2 as charged cruelty to children in the 3rd degree, and indictment 18 SC 157610?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is freely.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for felony charge and 12 months from today for what are now the 2 misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about excuse me. November 29th, 2017, officers responded to 2301 Godby Road, G-O-D-B-Y, which is located in Fulton County. They met with the victim, Chandrika, that's S-H-A-U-N-D-R-E-I-K-A, Devizin, that's D-E-V-E-Z-I-N. She advised that she had been in a verbal argument with the defendant, and during this argument, he grabbed the phone out of her hand. When the victim tried to retrieve that phone, the defendant then began to strangle her in the presence of her 8-year-old daughter, Ania. That's A-N-N-I-Y-A-H. Officer spoke with that child, and she stated that when she observed the defendant attacking her mother, she went to the kitchen, grabbed a knife, and that knife cut the defendant when he attempted to grab it from her. The officers observed visible discoloration on the neck of the victim. While officers were on scene, the defendant returned to the scene, began arguing with the victim, at which time he was placed under arrest. Your Honor, the defendant does not have any felony convictions. I would note, in looking over his criminal history, he does have from 2009 he was charged for several felonies, including hijacking a motor vehicle, possession of a firearm, and theft by taking. It looks like all but one of those charges, the theft by taking, were null prost. He entered a plea under the First Offender Act to that remaining count of theft by taking. He does also have some subsequent convictions for driving while license suspended, but from what I can tell, does not have any other convictions. He does have a few other arrests, a total of 7 cycles. Your Honor, this is a negotiated plea. We are asking that he be sentenced to 24 months of probation with those conditions mentioned and any other Your Honor deems appropriate.
You understand the nature of the charges against you?
Yes, ma'am. Excuse me, sorry about that. But on what he was saying is not all correct because
Hold on a minute. I'm gonna let you talk in a minute, okay?
Yes, ma'am.
You understand the nature of the charges against you?
Yes, ma'am.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, ma'am.
Has anyone made any threat or promise to influence you to plead guilty?
Not at all.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, the right to appeal your case and be represented by counsel if convicted by a jury? Do you understand that by pleading guilty, you're giving up all of those rights?
Yes, ma'am, I do.
Do you understand that if you are not a U.S. citizen, a plea of guilty will have an impact on your immigration status?
Yes, ma'am.
Understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate.
Yes, ma'am.
How do you plead to the charges, guilty or not guilty?
Guilty.
Are you in fact guilty?
Yes, ma'am.
Is your plea made freely and voluntarily?
Yes.
Ms. Jones, are you satisfied that the client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I do, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered, and I will accept your guilty plea. Go ahead, Ms. Jones.
Thank you, Your Honor. As Mr. Dixon indicated, he's 30 years old. He has 2 minor children, a 5-year-old who actually lives with my client. Prior to being arrested, Your Honor, he was working at Popeyes as a cook, which is, I think, the condition of the curfew. I'm not really sure how late Popeyes stays open, maybe 9:30 or 10, probably 9. And so he does cook and he works the varied hours at Popeyes,
Your Honor, and he's indicated to me that he has spoken with his employer and they are going to allow him back to that job, Your Honor. And speaking with him in regard to the facts, and I will note that we did have a waiver of prosecution from the complaining witness in this case. I'm not the one who actually received this. It was Ms. Wolf, who was his attorney prior to this incident. And in speaking with my client about the incident, he acknowledges there was a fight. He doesn't necessarily agree with all of the facts, but he does acknowledge they got into a fight. The state does have enough for a battery charge, and they were arguing in front of the child, which is enough for the cruelty to children, which is why he has decided to plead guilty today, Your Honor. My understanding also is they are no longer boyfriend-girlfriend, and they haven't spoke since this incident. So we have no issue with a no contact, Your Honor. We are respectfully requesting that you follow the agreement, Your Honor, and sentence him to probation with the reduced charge.
Did you have some questions, Mr. Dixon?
That was the only thing that I had was the curfew time, and I just wasn't understanding why would I have to be on the curfew, but I'm willing to do everything else dealing with probation, like the reporting and paying my fine and getting into class. I have no problem with. I was just concerned about the curfew time because I have, like I said, I have children. I do like to go out and have fun with my kids, and that's the only thing I wanted to know, Your Honor.
24 months on probation, special conditions of probation to include no contact with the victim. This is not your child, correct?
Yeah, I have no children by her. I haven't spoken to her since this incident had happened in 2017. I've been on my own with my own kids and living life, trying to live my life like I'm supposed to by working and taking care of my own.
Um, 24 months on probation, random drug screens, 40 hours of community service, an 11 p.m. to 6 a.m. curfew. 11, did I say 11 a.m.?
Yeah,
11 p.m. Okay. I thought maybe I said 11 a.m. And you have to be employed or in school. How far did you go in school?
I graduated high school.
Well, I'm not going to make it a condition of your probation. Your record's not all that bad, but I would suggest you either get back in school or get a trade, or you're going to be working at Popeyes the rest of your life.
No, I'm not. I'm trying to actually open up my own business, working on cars.
Well, you might want to go to Atlanta Tech or somewhere and get your certificate so you have it.
Yeah, I know. It's just me dealing with my kids and just trying to live a happy family is just the only thing I really worry about at this time. I'd rather just be at home with my kids and maintaining a regular job. It don't matter to me as long as I have my children. And I was just, you know,
Your Honor, the state would just inquire if Your Honor is also going to impose a family violence intervention program.
Nope. Not on this one.
Yes, Judge.
so I just have to report to my probation officer and random drug screens and pay my fine. Now, is there any way that I can take the community service off and actually pay a fine by that, ma'am?
No.
Okay, so I have to do 40 hours of community service.
Correct.
All right, no problem. I will have no issues doing my 24 months on this probation and reporting and paying my fine.
Once you get finished the community service and you go drug-free for at least 6 months, you can call Ms. Jones and come back, and I may suspend all the reporting requirements.
Yes, ma'am, no problem. I would love to do that.
Okay?
Yes, ma'am.
All right. Good luck. Yes.
Your Honor, my understanding is misdemeanor probation is not on the Zoom, so I have a phone number he needs to call, and I wasn't aware of that when I met with him yesterday. Otherwise, I would have given him this information.
All right.
And do you have a pen and paper handy so I can give you a number?
I can grab one. 1 minute, ma'am.
Perfect.
Go ahead, Ms. Jones.
Okay, it is 404-591-3180.
Read it back to her.
The number you just gave me is 404-591-3180.
That's correct. And you still have my card, correct?
Yes, ma'am, I do.
Okay.
So if you're having issues reporting, just give me a call, okay? But usually it's going to take about probably a couple days for them to get your information though into the system. But just keep calling, and if you have problems, give me a call.
All right. So with this being said, I will upon my release will be. That's all I want to know.
Call a week from Monday.
A week from Monday.
Yes.
All right. And like I said, thank y'all, and y'all have a blessed day.
Good luck.
Thank you.
We have Mr. Harper.
Yes, Your Honor, we got position 5 and position 6, Mr. Harper.
Y'all have gotten really good at this. Hey, Mr. Harper,
How are you, Your Honor? How you doing?
can you hear me?
Yes, ma'am. Yes,
Okay, can you do me a favor and just pull that under your mouth just while we do this so we can hear you clearly?
ma'am, Your Honor. Speak up.
Okay, and you're gonna have to speak up for me.
Yes, ma'am, Your Honor.
All right, and is Miss Jones your attorney?
Yes, ma'am, Your Honor.
Have you had an opportunity to speak with her about your cases?
Yes, I have.
And did she go over the indictment and the plea sheet?
Yes, she did.
Okay, you understand that you would have the right to be here in the courtroom if you wanted, but right now the jail is not bringing folks to court. Are you okay with proceeding via this Zoom program?
Yes, ma'am, I am.
Okay, also, if you were in court, you would have to sign the indictment and the waiver of rights form, all right? Are you okay since you can't be here with me initialing and signing those on your behalf?
Yes, ma'am, Your Honor.
Okay. Go ahead, Mr. Whitenauer.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to ask you some questions, and if you could please answer out loud, yes or no, or as appropriate, so that the court reporter can take down everything that we say. Agreed?
Yes, sir.
All right. Let's go ahead and begin. First, if you just raise your right hand. You swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Please lower your right hand. Please state and spell your true, correct, and legal name.
Jeffrey Jerome Harper.
All right, can you spell your name, please?
Jeffrey, Jeffrey.
Okay. Sir, are you at this time taking or under the influence of any alcohol, drugs, or medication?
I'm taking medication for mental health, sir.
Okay. And does that medication affect your ability to understand the nature of the proceeding today? Does it affect your ability to understand what we are doing here today?
No, sir, it don't.
All right. How old are you?
58.
How far have you gone in school?
11th grade.
Are you able to read, write, and understand the English language?
Not able to read, sir.
Okay. Do you understand that you're being charged with the following offense in indictment 19 SC 173-162, theft by shoplifting?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And sir, have you had the opportunity to speak with your attorney about the waiver of rights form?
Yes, sir.
Okay. And did you understand all those rights that you discussed with your attorney?
Yes, sir.
And are you okay with the judge initialing that form for you because you're not in court today? Did you understand all those rights that you discussed with your attorney?
Yes, sir.
And are you okay with the judge initialing that form for you because you're not in court today? Did you understand all those rights that you discussed with your attorney?
Yes, sir.
Okay, I'm hearing a lag in the audio here. So I'll continue and hope that's been resolved. Sir, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
And counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment?
For the purposes of this plea, yes.
And sir, has your attorney advised you the minimum and maximum sentence for the charge that you're pleading to today?
Yes, sir.
And for the one count of theft by shoplifting, it's a sentencing range of 1 to 10 years in confinement. Do you understand?
Sir.
And Ms. Jones, this is, I believe we've come to an agreement on this?
I believe so.
Okay. And sir, you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 1, the balance on probation. Do you understand?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand the court can sentence you to the maximum on the charge?
Sir.
All right. Do you understand that this guilty plea is going to be permanently recorded on your criminal history?
Yes, sir.
Understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts.
Yes, sir.
Understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today.
Yes, sir.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, I do.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Sir.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes, I do.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are, in fact, guilty?
Yes, sir.
How do you plead to the charge of theft by shoplifting in indictment number 19 SC 173162?
Yeah.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
No, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Sir.
And lastly, do you understand that you have only 4 years from today for the felony charge to file what is called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about November 5th, 2019, officers with the Atlanta Police Department responded to a call from MARTA police officers who had detained the defendant after he had been caught shoplifting from a CVS pharmacy located at 12 Broad Street, which is located in Fulton County. In total, he had removed 4 pieces of merchandise with a value of $94.83. These incidents were captured on surveillance video. He was placed under arrest at that time. Your Honor, this is being charged as a felony as a result of the fact that he has committed at least 3 prior theft by shoplifting offenses, 2 in 2002 and a 3rd in 2017. He does have a total of 44 cycles in his criminal history. Of note, he has 6 felony convictions. The earliest starting in 1985 with theft by taking, 1994 theft by shoplifting, 2001 burglary, 2003 theft by taking, 2017 theft by shoplifting, and 2019 burglary. Your Honor, the state is recommending 10 years to serve one. That 1 year is cannot be suspended by statute. We are asking that you impose any other conditions that you deem appropriate, including that he not return to that incident location or any other CVS. And then also, Your Honor, we do need to take up the matter of his probation case. On that, we are asking that he be revoked for 1 year and the balance reinstated.
You understand the nature of the charges against you?
Ma'am, Your Honor.
Are you now under the influence of any alcohol, drugs, or any other substances?
No, ma'am, Your Honor.
Has anyone made any threat or promise to influence you to plead guilty?
No, ma'am, Your Honor.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, and the right to appeal your case and be represented by counsel if convicted by a jury? Understand that by pleading guilty, you're giving up all of those rights.
Yes, ma'am.
You understand if you are not a U.S. citizen, a plea of guilty could have an impact on your immigration status.
Yes, ma'am.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
Yes, ma'am.
How do you plead to the charges, guilty or not guilty?
Guilty, Your Honor.
Are you in fact guilty?
Ma'am, Your Honor.
Is your plea made freely and voluntarily?
Ma'am, Your Honor.
Ms. Jones, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I do, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered, and I will accept your guilty plea. Tell me again how old you are, Mr. Harper,
58,
and how far did you go in school?
11th grade.
Go ahead, Ms. Jones.
Thank you, Your Honor. To address the probation issue, Your Honor, in the 18 SC, we will stipulate to that. That indicates that he basically violated by committing a theft as well as leaving a program that he was supposed to be at, which was Michael and Michael, Your Honor. And I think he pled to that at or around June of 2019. In speaking with my client regarding Michael and Michael, he indicated to me that while they were willing to take his money because he is on SSI, he wasn't getting his mental health or his mental health medication or his medication he needs for an ongoing medical condition. I spoke with Ms. Cole regarding that, and she's indicated to me that they have been having some issues with Michael and Michael. However, the whole pandemic thing kind of hit and she wasn't able to completely follow up with that, but she did note that there had been some flags raised. Your Honor, he was referred to the Hope House, but since they were shut down, Ms. Cole did refer him to the STAND program. He was supposed to have an interview last Friday, and I'm not sure if he did or not. Ms. Cole wasn't able to confirm that as of yesterday. Also, in speaking with my client, he has been a resident of the Ponce de Leon Center, which is a part of Grady, and they also have a housing component of, it's called the living room, and it's for folks who have conditions or ongoing medical conditions like my client does, Your Honor. He admits to the shoplifting, Your Honor. He was just struggling out on the street after he left Michael and Michael. He was trying to get back to the Ponce de Leon Center. However, he was just downtown. He just ran out of options, Your Honor. So we are requesting that he get a 10-serve-1, and that would be commuted to a time-served sentence upon entry into and completion of a program approved by the court. STAND would obviously, I think you probably want to wait for transport. Ponce de Leon Center, Your Honor, is one where he actually has to report off the street. That is one of the big reasons why Ms. Cole could not refer him there, because they don't take, for whatever reason, referrals when people are in custody. And I'm not sure why that is. And I didn't ask Ms. Cole, but that is what we're requesting today, Your Honor.
How much time's left on his probation?
The defendant has 8 years, 5 months, and 10 days remaining.
Are you waiving on the revocation?
We are, Your Honor. We stipulate he did what they allege.
All right, I'm going to revoke 5 years on the revocation. What's the case number on that? Oh, we've got it right here. I'm sorry. On 18 SC 163634, I'm going to revoke 5 years, reinstate the balance. Special condition of that probation is entry into and completion of an inpatient treatment program to be approved by the court. Special condition of that probation is also to complete the program, random drug screens, an 8 p.m. to 6 a.m. curfew, 19 SC 173162, 10 years probated consecutive to 18 SC 163634. Special conditions of that probation are completion of an inpatient drug treatment to be approved by the court, follow-up care, random drug screens, and you cannot go to any downtown CVS. An 8 p.m. to 6 a.m. curfew or the more restrictive of the program. And Ms. Jones, yes, I'm going to wait till there's a bed space, but then if you can find someone that can transport him, I'll consider that.
Okay.
In other words, if we can find somebody off the street, if the jail's not transported.
Right. And we have somebody in our office who is working with the accountability court. So we're still sometimes able to get transportation as long as we give them ample notice. So I'll inform Ms. Cole of the inpatient program and we'll go from there.
Okay.
Your Honor.
Yes.
So please correct me if I'm mistaken, but for this offense, it being a fourth, it's my
okay, I'm sorry. Let me redo the sentence on the shoplifting. 10 to serve 1 backloaded consecutive.
Yes, Judge.
It says it's a year to serve. That's all the statute says, Mr. Whitenauer. It doesn't say it has to be on the front end. I
Yes,
don't
Judge.
believe.
It does not.
And I've given him 5 years to serve on the probation revocation.
Yes, Judge.
That's like the child molestation I had where I gave a subsequent 20 years probation and they sent it back because he didn't get the year on probation on the child molestation.
Right.
So, all right, Mr. Harper, this is it for you. If the program we get you doesn't work, you can't just walk away. You have to come back and talk to me, all right? All right, good luck. All right, do we have Mr. Graves?
He's right here, 2 North.
Good morning, Mr. Graves.
How you doing, man?
Good, how are you doing?
Ain't doing too much, man. I'm a little sick, though. I'm trying to make it, man. It's hard. I got a
I'm
little
sorry.
mental problem. I got a little mental problem.
I'm sorry to hear that. I'm Sean LaGrua. I'm the judge on your case, all right?
Yeah.
Have you had an opportunity to talk to Ms. Jones about your case?
No.
I'm Miss Jones. I looked a little different yesterday. Remember, I don't have the face mask on and my hair's not all pulled back, but I'm the lady you talked with yesterday, okay?
Okay.
Okay.
All right, did you talk to Ms. Jones?
No.
Ms. Jones came out, did somebody come out to the jail and talk to you yesterday?
Yes, ma'am. She gave me a card. I know she gave me this card.
Okay, so you've had a chance to talk to her about your case and your charges.
Yeah.
All right, and you understand that right now, the jail's not bringing people to court, okay? So you have a right to be here in the courtroom where I am, if you want to be, but if you're okay, we can do this via this Zoom computer program. Are you okay with that?
Yeah, I take medication.
We know.
Okay, now, if you were here, you'd have to sign this indictment, okay? And the plea sheet, but you're not here, so is it okay if I sign an initial for you?
Yes, ma'am.
All right, go ahead, Mr. Whitenauer.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to ask you some questions, and if you please respond out loud, yes or no, or as appropriate, so that the court reporter can take down everything that we say. Agreed? All right. If you would, please raise your right hand. Your right hand. Do you swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God? Can you say yes or no?
Yes, sir.
All right, you can lower your right hand. You can put your hand down.
Mr. Graves, you can put your hand down, but I need you to speak up because you see the lady on the screen where it says court reporter?
Yes, ma'am.
Real pretty lady in the pink?
Yes, ma'am.
All right, she's taken down everything, and if she can't hear you, we can't do this, okay? So I need you to speak up nice and loud.
All right.
Go ahead.
Sir, if you would please state and spell your true, correct, and legal name.
My name Ernest Graves. My
Okay.
name Ernest Graves. My name Ernest Graves. I don't know how to spell my name that right. Call me this bitch head.
Go ahead, Mr. Whitenauer.
Yes, Judge. Sir, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I take medicine.
Okay. And does that medicine affect your ability to understand what is going on today?
Yeah, I take elixir. It keep me calm down. It keep me calm down, not to get upset, like it get violent and stuff like that.
Okay. So you understand what we're doing here today?
Yes, sir.
All right. And sir, how old are you?
I got a birthday coming up, November 22nd. I don't know really, sir.
Do you know what year you were born, sir?
63. November
63. All right. So you're 57.
Okay, thank you, man. I'm getting
And
a little
sir,
old.
You're a nice young man.
I know I do good. I get upset though.
and sir, how far did you go in school?
12th grade all day. I finished.
Very good.
They said.
Understood. Are you able to read, write, and understand the English language?
I read and write a little bit.
And sir, do you understand that you're charged with battery, family violence, and indictment 19 SC 171223?
Yes, sir.
All right. Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
I plead guilty.
All right. And that's fine. I'm just trying to make sure that you understand all of your rights, okay? So listen to the question and then respond appropriately, either yes or no. Okay. And sir, did you have an opportunity to speak with Ms. Jones yesterday, your attorney?
Yes, yes.
All right. And did you have an opportunity to talk about the waiver of rights form? It lists all the different rights that you're giving up in entering this plea.
Yeah. Yeah.
All right. And did you understand all of those rights? Yes?
You have to say yes out loud, okay?
Yes.
Okay, thank you.
All right. And are you okay with the judge signing that form for you because you can't be in court today?
Yes.
All right. And sir, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss your case with your attorney?
No. No.
Are you satisfied with her services?
Yes.
All right. And counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment?
We do.
And sir, has your attorney told you about the minimum and the maximum sentence that you could face for this charge of family violence?
No. No.
Okay. Are you, so just so that you're aware, it's a sentencing range of 1 to 5 years in confinement. That's what the statute says. Do you understand? You need to say yes or no. So the court reporter, all right, thank you. And sir, do you understand that this is a negotiated plea of guilty, which means the state will be making a recommendation to the court for your sentence?
Yes.
All right. And do you understand that the state's going to be recommending 5 years to serve 60 days, balance on probation, that you complete the family violence intervention program, that you enroll and complete an inpatient mental health and drug abuse treatment program, you have no violent contact with the victim, your mother, that you be employed or in school, that you follow a curfew, you consume no drugs, no alcohol, that you be subject to random screens. Do you understand that?
You got to say yes or no.
Yes. Yes.
All right, thank you. Do you understand that by entering this plea, it will be reflected on your criminal history? Sir, can you hear me?
Yes. Yes.
All right. So again, if you can just respond yes or no to my questions so that the court reporter can take down your response, okay?
Okay.
All right. Sir, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes. Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or bad consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes. Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, that you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
I incriminate yourself.
I'm sorry?
Yes, yes.
Okay. All right. Do you understand that by pleading guilty, you are giving up the following rights? I'm going to list a few rights here. Just listen to them, and at the end, let me know if you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
All right. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive all these rights that I've just mentioned and enter a guilty plea because you are in fact guilty? All right. Sir, how do you plead to the charge of family violence battery in indictment 19 SC 171223?
Guilty. Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes. Yes.
Do you understand that you have only 4 years from today for this felony charge to file what is called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about July 4th, 2019, officers with the Atlanta Police Department responded to 183 Mount Zion Road, which is located in Fulton County, and spoke with the victim in this case, Ethel Kempson, Kempson, who is the mother of the defendant. She advised that he struck her on the top of her head after he became upset that she refused to give him money to purchase a pack of cigarettes. The officers observed injuries, which was a swelling knot on the top of her head, and it was based on that report and observations that warrants were taken out for his arrest. Your Honor, this defendant does not have any felony convictions. He does have a total of 26 cycles in his criminal history, one of which includes the underlying family violence battery, which is alleged in the indictment. That was from 2006 out of DeKalb County. This defendant does have some misdemeanor convictions, including simple battery in 1990, carrying a concealed weapon in 1993, 1999, theft by taking, and a couple, and then that 2006 family violence battery just mentioned, and then another simple battery in 2006. But it is my understanding, Your Honor, that there are some mental health and drug abuse issues. I did speak with the victim in this case, and she did inform me that those are some issues that this defendant has been dealing with for several years. She advised that he has been diagnosed with schizophrenia and bipolar disorder, and has in the past treated with the Grady Act team. She indicated that she would be fine with the defendant living with her. Obviously, the state's main concern is that he first receive the treatment he need before that were to occur. So we are asking for 5 years, serve 60 days, balance on probation, family violence intervention program, a treatment program, which is inpatient, and any other conditions Your Honor deems appropriate.
Yes.
Mr. Graves, do you understand the nature of the charges against you?
Yes, yes, ma'am.
Are you now under the influence of any alcohol, drugs, or any other substances that keep you from understanding what's going on?
No. No.
Has anyone made any threat or promise to influence you to plead guilty?
No.
You understand that by pleading guilty, you're giving up the following rights: the right to a jury trial and to be represented by counsel at that jury trial, the right not to incriminate yourself, the right to question your accusers, the right to subpoena witnesses on your own behalf, the right to testify on your own behalf, the right to appeal your case and be represented by counsel if convicted by a jury. Do you understand that by pleading guilty, you're giving up all of those rights?
Yes.
Do you understand if you are not a U.S. citizen, a plea of guilty could have an impact on your immigration status?
Yes. Yes.
Do you understand that the court's not bound by any promises, recommendations, or reductions, and I could sentence you as I deem appropriate?
Yes.
How do you plead to the charges, guilty or not guilty?
Guilty.
Are you in fact guilty?
Yep.
Is your plea made freely and voluntarily?
Yeah.
Ms. Jones, are you satisfied that your client is competent, understands what's going on, that the plea is voluntary, and that there is a sufficient factual basis for entering the plea?
I do, Your Honor.
I will find that there is a sufficient factual basis for entering the plea. I further find the plea of guilty to be knowingly, voluntarily, and intelligently entered, and I will accept your guilty plea. Go ahead, Ms. Jones.
Thank you, Your Honor. As my client indicated, he was born in '63, which makes him 57 years old. He did complete high school. However, he was in special education, Your Honor. In speaking with, his mom, she indicated that he was in special education and he didn't really get a lot of help because obviously we think back in those days and in that era, there just weren't the specialized care and education that we have now. So I do believe he understands absolutely what is going on today, but his language is a little bit more simplistic because of some of those issues, Your Honor. In speaking with mom as well, she indicated to me that he had been part of the ACT team out of Grady, and at some point he was no longer a part of that team. It sounds like in regard to this incident, I spoke with my client about it. He acknowledges he hit his mom because he was, a little bit upset that she wouldn't give him money for cigarettes. He acknowledges that. Yes, I know. And in speaking with mom, she indicates that he didn't get a shot, and so apparently he gets his mental health medications via a shot, and for whatever reason he hadn't gotten it, and I wasn't really clear as to why. There was just a lot of noise in the background when I spoke with her, Your Honor. I did speak with Ms. Cole regarding Mr. Graves, and she did confirm that he was part of the ACT team. However, she indicated that he left in 2015, so there would have to be another referral done for him to go to that program again, which we can certainly do, Your Honor. I spoke with mom. She likes the ACT team. She thought that they did a really good job and that she is willing to have Mr. Graves live with her. She was a very spry lady. She was kind of fun to talk with. I think she was 72 and still driving, taking care of grandkids. I wish she could have been here, but unfortunately that wasn't possible, Your Honor. So we think that probation and a program to keep Mr. Graves on track is good. And that's what we discussed yesterday, right?
Yes.
Yes, and we got to stay on our medications, right?
Yes.
Yes, and he understands and needs to stay on his medications. He is also on his medications currently. I spoke with him about that. And Your Honor, we did discuss first offender for him. And I forgot to tell Mr. Whitenhauer that simply because this is his first felony. He is on SSI. So I don't want to, if we can keep a felony off of his record, if he's able to comply with the conditions Your Honor imposes, I think that would benefit Mr. Graves. And so that is what we are requesting, Your Honor.
And if I could, I'm sorry, Your Honor.
No, go ahead.
I do see on his GCIC that he did enter first offender to robbery in 1986.
Okay, when we didn't have his record, Your Honor, when I noted on Odyssey, I didn't see anything, so that's fine.
Mr. Graves.
Yes, ma'am.
If I let you out in the next few weeks or so, are you going to stay on your medication?
Yes, ma'am. Yes, ma'am.
And you're never going to be mean to your mom again?
No, ma'am. I'm sorry, ma'am. I'm sorry, ma'am.
You should be apologizing for that, all right?
I'm sorry. Yes, ma'am.
Your
How
Honor,
long's- how long's he
I
been
think this,
in?
I'm sorry.
How long's he been in?
I have that he's been in 22 days as of when this is booked. However, I would just make a request just for our office and for Mr. Graves as well, that we be allowed to make that referral to ACT to make sure that there is going to be placement for him. And we can always just put this on a status docket in a week or 2 weeks to ensure that that's been done. Because I know that ACT, you have to, report, but I just want to make sure that Ashley gets a little bit of lead time for that to happen.
Well, and Ashley's leaving as of Monday, I understand.
Tuesday, Your Honor, but I've already, I've got, I think her name is Lydia, and she's we're going to try to smooth transition everything, Your Honor. So you've already been assigned a new a case or social worker, Your Honor, and we're going to hopefully, knock on wood, hit the ground running, so to speak.
I'm going to do 5 years probation on this, special conditions of probation, that he be under the care of an ACT team. He take his medication as directed, no violent contact with your mother at all. Mr. Graves, you're going to be under my thumb for 5 years.
Okay, man.
You better not be mean to your mom who's willing to take care of you.
Okay, man.
All right, there's now, that's all right. Can you calm down a minute and listen to me for a minute?
Yes, ma'am.
All right. There's nothing wrong with having some mental health challenges, but you have to stay on your meds.
Yes, ma'am.
All right. We're not going to sign this sentence for a couple of weeks until we make sure he has a referral and we know where we're sending him. Has to stay on his meds, a 9 p.m. to 6 a.m. curfew for now, random drug screens.
All right.
All right. So as soon as we get the ACT team together, Mr. Graves, we'll get this taken care of. All right.
All right.
Mallory, we're going to go ahead and do the sentence, but hold it.
Okay.
That way we won't have to come back.
All right.
All right.
Thank you.
Good to see you, Mr. Graves.
Thank you.
You'll be out in a few weeks, okay?
All right. Thank you.
All right. Take care of yourself.
All right.
Yeah, if we can get on that ACT team, Ms. Jones.
I will, Your Honor.
As soon as we even get a date, since he's already been referred previously, it should be a little faster than usual. And if he's only been in 22 days, they probably haven't gone after his benefits yet.
Okay.
So the sooner we get this set up and I can let him out, the less chance there's going to be a delay in benefits.
Okay. I'll get on that, Your Honor.
All right. Is that the calendar?
That's it.
Yay. All right. We did more of other folks' stuff than ours, but we'll talk next Wednesday. Did
Okay.
Mallory tell you Wednesday afternoon, let's talk? I know y'all are having some problems with sentences at the jail. If you could figure out to the extent you can what the problems are and what I need to do to fix them, if there's a fix for them. Go ahead, Mr. Whitedown.
I guess that hadn't been shared with me. Is it just for release to programs? Is that what's going on, Tanya?